Good evening, everyone. Tonight is a regular meeting of the South Kingstown Planning Board. The date is Tuesday, March 26, 2024. The time is 3 minutes past 6. The first item on our agenda is roll call. Joe Murphy.
Here.
Susan Axelrod. Here. Robin Pothier.
Here.
Elizabeth Karp.
Here.
Peter DiStefano.
Here.
And Maria Mack is here. Our next agenda item is the consent agenda. This consists of approval of minutes January 23rd, 2024, February 15th, 2024, work session, February 27th, 2024, regular session, and the report of the administrative officer. If there are no changes or corrections, would someone like to make a motion to approve the consent agenda?
I'll make that motion.
We have a motion from Peter. Do we have a second?
I'll second.
Second from Liz. Is there further discussion? Hearing none, all in favor say aye. Aye. Motion carries. Our next agenda item is a public hearing which has been continued from January 23rd, 2024. We have a letter from the applicant requesting a continuance of this public hearing for preliminary plan, major subdivision comprehensive permit, Fieldstone Farm, to Thursday, May 30th, 2024, at the Planning Board regular session meeting. Would someone like to make the motion to continue this item?
Did we get an extension for the time for review?
Mics, please.
Did we get the related extension for our time for review as much as the time they requested for the extension?
Yeah,
Yes, of July 31st.
I'll make that motion.
We have a motion from Joe. Do we have a second? Second from Peter. Any further discussion? Hearing none, all those in favor say aye.
Aye.
Aye. Motion carries. Our next agenda item is development plan review advisory to zoning, continued from February 27th, 2024. Commodore Manor DPR, proposed change of use to residential occupancy for more than 3 unrelated people. Is there anyone representing the applicant? Good evening. And please state your name for the record.
Thank you. I'm Sean Heavenor. This is my partner, Ames Kaiser, behind me. We submitted on March 17th an email to the planning board with a letter that I understand didn't get attached. But do you guys have copies of that letter that was submitted?
They were emailed to us. I don't have a hard copy, but I know that I have read it. Has everyone else had the opportunity to read it? And perhaps you would like to go through it regardless?
Yeah, I'm happy to just read through it. It's not too long. It's basically a response to the meeting that we had, some concerns that were raised by the board and by some residents as well. So we noted during the February planning board meeting, there were several concerns that were raised, which we would like to provide some clarity and a response to. First, regarding traffic on our shared private road, a point was raised that the road is narrow and that if 2 cars meet, then one must back up to make room for the other pass. We disagree with this as a blanket statement and present it as partially true. There are 2 places in the road where this does apply, but the rest of the road allows for room for 2 vehicles to pass each other. We noted further that this is true for other roads in South Kingstown. I think Ames wants to shed some light on that.
Could you also state your name for the record, please?
Sorry, Ames Kaiser. Because the traffic was such a major issue at the last meeting for some of the board members as well as the neighbors, I just wanted to, I spent a lot of time thinking about that, and I do a lot of, my travels take me through South Kingstown a lot, and as I was making my way around, I noticed a lot of other shared private roads where there was the same situation that existed, a single lane servicing multiple houses, some big houses, and in some cases, very, very long situations where there's a lot of potential for cars to have to pass each other or pull over. As it pertains to our house, our first we have two driveways. Our first driveway is the very first driveway off the road. So anybody using our first driveway is going to pull off of our shared road into our property. Before we are the first driveway. So before we pass any of the other residents' houses, half of the traffic at our place would pull off. We also recognize that if we could direct any deliveries that were coming to our house, Amazon being the most common one, we'd certainly be willing to do that, put up a sign and direct any deliveries to our first driveway, which would divert that traffic off the road very quickly. In my travels, I just noted several other situations where that same situation applies, and the way they addressed it was occasionally there would be a turnout where a car would pull over and wait for another car to go by. There are some very informal versions of that on this road, and we'd certainly be willing to assist in creating at least one more strategic one that where on our side of the road in our little wooded area to help alleviate that issue.
I'll continue through the letter that was sent. Second, regarding maintenance of the road, a point was made that we've never offered to pay for any maintenance. No one's ever asked us for any money to do so. To the best of our knowledge, there have been 2 snow plowings during the time that we've owned the property and no other road maintenance costs. Regardless, we've sent a letter to our neighbors offering to pay for 20% of the costs of maintaining the road. This takes into consideration the 5 homes that use the road, but not the Hale House, which I suspect we can all agree to cover that expense for as a small contribution to the good work that the Land Trust is involved with. Third, concerns were brought up about the number of vehicles we should allow to park on our property. We would agree to put in our lease that any car in excess of 10 cars parked on the property would be towed at the owner's expense. We would also agree to specify in our lease exactly where our tenants and their guests need to park, and if there are any cars in a location other than specified, then those vehicles would be towed at the vehicle owner's expense. Fourth, allegations of trespassing were raised. We agree to install a sign at the bottom of our the easternmost driveway to remind our tenants and guests and anyone else that finds themselves on our private road that the road beyond that point is our neighbor's private property and that there's no trespassing permitted, walking or driving. We'll also put this in our leases going forward so that it is a term that each tenant is aware of and agrees to at the start of all tenancies with a penalty of termination of tenancy for any violations. We agree with our neighbors that all property owners should have 100% right to their own privacy and consider it our responsibility to help enforce this. Fifth, concerns regarding the pond access were raised. The same reminder signage as mentioned above will apply to pond access on the Hale House property. Please note that our pond access is very steep. It's a very steep, challenging to navigate path which leads from our shared road to the pump house and does not actually go all the way down to the water. We strongly disagree with the statement that was made that anyone could easily access the pond on our property. The terrain between the road and the woods is heavily wooded and extremely steep when you get down to the embankment. The average person would find it very challenging to walk down near the pond. We own and maintain a narrow trail which goes to our pump house and does not continue to the pond. Sixth, we'd like to go on record with some additional information about traffic. The approval of this special use permit would allow up to 6 unrelated occupants, which would most likely result in 5 to 6 cars parking at the property and using our shared road. We recognize that our neighbors are not used to seeing this number of cars associated with our property, as it was mostly vacant for several years, and even prior to that had been significantly underutilized for many years. To state the obvious, 2625B is a very large house that has been there for over 70 years, which predates all of the other houses on the shared private road, excepting the Hale House. Per the town records, the other houses were built in 1963, 1970, 1979, and 2002. Indeed, it should not be easily dismissed that the portion of private shared road in question was originally built for our property to utilize both driveways we currently enjoy. This 16-room storied mansion built in 1953 has always had use of this road, and several cars parking there is not only our right, but the obvious original intent and historic use of this property. It is understandable that our neighbors were unaccustomed to and upset by the increased use as they'd become accustomed to the aforementioned underutilization of this property. So any increase to the past few years is a change. That said, we are happy to discuss and would welcome a major improvement of the shared road should our neighbors wish to discuss this cost, the cost that this would entail. We've been working closely with the town to bring the property into compliance with everything that has been asked of us, and will continue to do so. We have every intention and desire to continue to be good neighbors and welcome increased communication to work together. As mentioned before, Ames is a very hands-on and present property manager and is at the property 3 to 4 times per week and open to conversation about anything that comes up. So, thank you.
Thank you. Do board members have any initial questions for these gentlemen?
I have a question about the tow. So last year I own a couple pieces of property and I tried to get a private vehicle towed off the property and it was a complete nightmare because I didn't have an agreement with a tow company. So I'm not sure if you've reached out to anyone, if you've ever had to tow anything off of a piece of property, but I don't know if it's that simple. That's what I found.
Just once, and it was not, it went out without a hitch, and it was just on my private property, and it was a car that was parked illegally on my property, and because it said in the lease that there was only 2 cars allowed on the property, I believe they might have called, the tow company might have actually called the police while they were on the property. So, if this is something that we move forward with, we'll certainly look into the complete legality of it. That's generally what we'd like to put in the lease to make it clear that we're not, we want to cooperate with that parking cap and make it clear to the tenants that that is a max, and we definitely would look into the logistics to getting that ironclad.
Other comments, questions at this point? Go ahead.
I have a couple questions for you. Can you show me where on this Google map the pump house is? You've referred to it, but I don't know where that is. Thank you. So does that property belong to your neighbor across the street?
Yes.
But you have a easement or some sort of access to that pump house?
Correct.
So now that you have a well in, is that pump house essentially retired?
Our short-term plan, without having, we just got the well in, as you know, and the well, the plumbing is still very much ready to go in that pump house, and if we needed it as an emergency backup, our short-term plan is just to keep everything in place because we just invested in this Super Duty filter and pump system not just a few months ago prior to putting the well in. So we have to think that through as to whether we want to keep it, go through the maintenance of keeping it active, or just ultimately shut it down.
Okay, thank you. So I'd also like to ask about the pullouts on the side of the road. I don't know where they are, but I guess between Route 1 and your second driveway, how many are there? And how many spots along that driveway do you have where cars legitimately could not pass one another should they come head to head?
It's a good question. There's not specific places where the road is twice as wide, but there are areas where there's a level area on the sides of the road itself that you can that someone can easily pull over, you know, and allow the other to pass. So it's,
There's one, I can, so, on
wish-
the initial.
I wish we had a pointer, I'm sorry that that's.
I know.
Jay, the 2022 aerial shows the driveway a little clearer. I don't know if you have the 2023.
All right, this first section right here off the street, can you guys see? Okay. This first section is steep, and it's single lane paved. There is shoulder, but the visibility is good from here to here. In other words, if a car was coming, this car could wait at the bottom of the hill. So this very first section, there's no turnout. And then as you go up here, here's the bottom of our driveway right here, where our first driveway comes into the road. Again, our pump house is right about here, and from here up to here, it's fairly wide. It's wide enough, certainly, for two cars to pass, and two cars have passed there. I've been pulled over on the side of the road here, and several times cars have gone by me, and trucks going back to other properties in the back. So there's a nice wide section in here for cars to pass. It gets narrow right here. It's a little bit, it drops off on both sides. So the road is high, and it drops off, like I said, on both sides, so it's tight here. So a turnout, so this is our second driveway. Our second driveway comes right up through here. It's hard to see. All right, yeah, here's our second driveway. There's ample room to get off the road right here. I would suggest, I would suggest widening right in here, which we'd be happy to do, and just create another turnout area. There's a reasonably flat area through here that would allow for us to, or somebody to pull over while somebody else passed right through here. It wouldn't involve a lot of work, possibly one or two trees to be cut, and the grade is level enough where it wouldn't involve a lot of terrain, changing of terrain at all through there. So cars can pass each other through here.
I'm sorry to interrupt. Are there blind spots along here where cars might abruptly approach one another head to head without?
Yes, it's this corner right here. This tends to be a little blind. There's also some work that we could do through here just to improve visibility, to your point. Right through here, it's very thick with rhododendron year-round. This rhododendron could be cut back more. I know that residents in the back have probably been working to maintain some width through here historically due to the absence of this property owner. We would be happy to cut this back plenty more to improve the visibility through here as well as right through here, which would, I believe, amend that blind corner a lot. It definitely would allow for you'd be able to see an oncoming car much sooner if this was cut back through here.
Thank you. I think that answered my question. I think I have one more. So I guess, for me, I'm not as concerned about your students parking on the road or otherwise causing general mayhem because they have something to lose. Your short-term weekend family rolling into town, though, how would you, I understand that a student's not going to be kicked off their lease. If you have a short-term rental, and unfortunately you've had a history, at least once, of abuse of the property and of the neighborhood, how is that enforced for people parking on the road Or, you know, if one of your neighbors is coming down the hill from their house and the road is blocked, what's the recourse? I'm not sure, to Peter's point, if they're allowed to tow a car off of a private road or off of private property, but if a neighbor finds themselves trapped on that road, what would be the plan for that neighbor to be able to move along and get that car out of the way? And that's a concern to me, not necessarily from your students, because they have something to lose, but these short-term rentals don't really have anything to lose. So what would the plan be to help out the neighbors with that situation?
So the situation you're describing is, we have a short-term renter there who's parked illegally on the road?
Mhm.
Or, okay, so it would seem that, you know, just like if anyone parked illegally anywhere, then a call could be made, the police could come, and they could be towed at the owner's expense. You're parked illegally, you're blocking a road, right?
But if it's a
Yeah.
private road or a shared road, I'm not, I don't know, I would have to ask our attorney,
Yeah.
how is that legally enforced versus a public street which has
Yeah.
posted rules? Like, I'd like to be clear on that, and whose responsibility it is to call a tow truck or the police, or how, what's your plan for that to take place?
You know, in regards to the question, you know, I think that the rental during the summer is probably not within the span of this permit that we're applying for, but that said, I think that would be my responsibility, our responsibility, to make sure there was nobody parked in the road. If there was ever something that was an issue, it would be our responsibility to make the call, go down and sort it out if we weren't already, you know, down that way. Communication is huge with our short-term renters. It is very clear and loud as to what the parking and the road use and the trespassing, everything that we've been talking about has already been, I've already been starting changing the verbiage on the listings. There's going to be signage, and there's going to be a lot of communication on my end directly with the people prior to them coming in to these sensitive issues, just to make sure this stuff doesn't come up. So if somebody just blindly ignored that, then it is clear enough in the Airbnb or Verbo or whatever the agreement is that we're working through, that would be a violation, and that's grounds for the guest to have to vacate. It's pretty clear in the Airbnb rules that if there's a major violation of the house rules, the guest could be asked to vacate immediately. And that's in the finer print, where you have to dig deep into Airbnb for when there's a breach, because I'm sure there's breaches that people have had to deal with before, so there's got to be a means for addressing that.
Thank you. I think that's all I have.
We have also received a letter from the South Kingstown Land Trust, as well as documentation relative to the approval for the Hale House in 2015. The letter is signed by Julia Landstreet. She is here this evening. I don't know if you would like to read the letter or make comments relative to the letter, or I could read the letter.
I've already read it. If you'd like to read it out loud, or if you'd like me to read it out
Yes,
loud.
go ahead.
Do you want me to?
Sure.
Julia Landstreet, South Kingstown Land Trust. We're in a butter across the road. We own the Hale House, a historic house. Dear Ms. Mack and fellow members of the Planning Board, the South Kingstown Land Trust is the steward, owner of the historic Hale House directly across the street from Commodore Manor. Before the Hale House was gifted to the South Kingstown Land Trust in 2015, there was a thorough and deliberate process to ensure that the adaptation of a single-family home in a residential neighborhood into a more commercial use would occur with minimal disturbance to the neighbors. And it has been quite successful. Limited hours, limited uses, frequent communication with our neighbors, and a deep respect for Matunuck's sense of place. The conversion of Commodore Manor first into a weekly vacation rental, then into student housing, happened with no communication with the neighbors, no potable water, no concern for fire safety, no understanding of the property line, and no plan for snow removal for their tenants. There may be other oversights, but this is what the property owners shared at the past various meetings. Earlier today, 3 documents were uploaded showing confirmation of a well, changes to lease language in reference to parking, and responses to concerns voiced last month. These piecemeal responses do not fully address the conversion of a residential property to commercial use. The home was built as a home and used as a home. Contrary to the suppositions of the current owners, none of the prior inhabitants considered it underutilized. The piecemeal response has left me with a number of questions. The uploaded documents address the short-term goal of seeking compliance for the current unpermitted use as student housing, but places all responsibility of parking, capacity compliance on the neighbors. Do the landowners pay when the tow truck wants to get paid up front? Are the tenants fully informed there's absolutely no pond access? At an earlier meeting, the landowners articulated their plans to address fire safety and increase the number of bedrooms for use as a weekly rental. Does this struggle to accommodate 10 cars then limit the capacity come summer when it becomes a vacation rental? The South Kingstown Land Trust developed a thoughtful and comprehensive plan of how to activate the Hale House in a manner and scale consistent with the neighborhood, a residential neighborhood with significant protected land, fragile ecosystems, and a profound sense of place. Sincerely, Julia Landstreet.
Thank you. Do you have additional comments? Thanks. Is there anyone else who wishes to speak?
I can talk a long time on it, but I would say
Oh.
nothing new. Thank you.
Thanks.
Elise Torello, I'm the abutter at 2625B. I actually have a lot to say about the most recent submissions by the applicants. Starting with the language that's going into the lease, premises includes 5 parking spaces. I don't know how that's going to work if there's 6 students living there. This is not a house where you can get anywhere without a car unless you call an Uber. So if it includes 6 parking spaces or 5 parking spaces and there's 6 students, I don't know how that's going to work. As to the other document, I'm going to address the road and traffic first. The applicant stated that the stretch of the road between Route 1 and the first curve to the east has room for 2 cars to pull over. That is extremely steep and it is narrow. There's grass on either side of it. One side is curbed and drops down into the Hale House lawn. The other side, you have to pull off into the bushes, but I can tell you right now, having lived on that road for 15 years, that when there is another vehicle coming up that road, you come around that blind corner, you're face to face with another car, you have to back up and pull onto either into the Hale House upper driveway that's right in front of the house or onto the grass, because 2 cars are not going to pass there. It's impossible. And if it's a truck, even worse, because they're not going to back out onto Route 1. So you've got to back up. And then once you get along where it straightens out, where the property line to the going towards the pond, it's a straightaway, but in order for 2 cars to pass, somebody either has to pull off to the right into the bushes or into the left onto the neighbor's lawn. And she installed sprinklers in that stretch, so you can't just go driving over her sprinklers. Past that, there's another blind corner, nowhere to pull off. So if 2 cars come face to face, you pull into the neighbor at 2625G's driveway. So, to say that 2 cars can pass anywhere on this road, the only way that can happen is if somebody pulls off into the bushes. Not an ideal situation. Whether there are other roads that are better or worse in South Kingstown, those roads are servicing homes. They're servicing private homes that families live in. they are not serving a commercial venture with students or Airbnb renters in it. The maintenance of the road, they never offered, and I did stand up here and say that we wanted a commitment from the applicants for 20% of the road maintenance costs. They did send us a letter asking us to commit to that as well. It's clear that they would like us to commit to any improvements to widen the road before getting to their first driveway. I personally am not willing to incur any expenses to allow their use of this property as a commercial venture. I would be willing to commit to 20% after that for snow plowing costs, but any improvements necessary for an approval of this project, I'm not willing to pay any of the cost for that. The parking, I think we've already talked about. I would like to comment on the statement that this house has been underutilized, and especially, I take exception to them stating that, you know, it's a mansion built in 1953, and the obvious and original intent and historical use was as, I'm not sure what the implication is, some sort of party house or something. But I spoke with somebody who lived in this house for several years, who happens to be a historian, and told me every single person who ever lived in this house. This house was constructed by a wealthy shipping heiress, and she lived there with just her and her husband. They had no children, and their servants. And he was an antique dealer, and the house was filled with antiques. She donated that house to URI with the intention that it would be URI's president's house. The URI did not want to use it as the president's house. They have a president's house on the campus. So while URI was waiting the required amount of time to dispose of the property, it was lived in by a couple, a middle-aged couple, just them in that house. After them was a husband and wife, middle-aged husband and wife. It's unclear whether they had any children living with them. After them was a woman and her husband, no children, just the two of them in the house. And after them, they sold the house to another couple who lived there, just the two of them. Big house for two people, but that's how they utilized the house. They lived there, they had family visit there, and it was a single-family house that was utilized in the way they saw fit. I have a 3-bedroom house. Right now, there is only 1 bedroom that's in use all the time. I have 2 grown children, and I have a father who live out of state. They come and visit me. They stay in those rooms those extra rooms when they're there. I do not consider my house to be underutilized just because there's only 1 bedroom in use. I guess that's all I have, other than to say this is a neighborhood with people who live here, and the applicants are not our neighbors. I actually looked up the definition of neighbor, and it's somebody who lives near you. They don't live here, they're never gonna live here. This is a commercial venture in a neighborhood full of single-family homes, and they are not emotionally invested in this place the way the people who live there are invested there. And these are our homes. My home is my sanctuary, and you know, I think a lot more consideration needs to be paid to the residents in neighborhoods when situations like this are arising in the future. Thank you.
Thank you.
Hi, I'm Bill McCusker. I live at 2625D Commodore Perry Highway 2. And I'm pretty intimate with the road. I've done a lot of the tree trimming and a little bit of the maintenance on the road. And it is definitely much narrower than the applicants are presenting. In fact, if you look at the beginning of the road, as it goes up from Post Road up to that driveway by the Hale House, you can see how it narrows down. Well, it's gone. But anyway, in any event, on one side towards the applicant's house, when you go, you have a bank right by where the road starts over, and then you go around the corner, it's a steep embankment going up towards the property. If the applicant was to widen it on that side, I would imagine a retention wall of some sort would have to be put on, or you would have to do something on the opposite side of the road with somebody else's property. I measured it, and I would encourage you all to go out there with your tape measure and confirm my measurements. You can see marks out there. The narrowest spot is right where you're looking now. It's like 11.5 feet wide. Goes up around the corner. The average width of that road is 12.5 feet wide. And up beyond the second driveway where our house is, there's one spot that widens up to 14 feet, but that's just about it. The average car width that I was Googling out is about 5.5 feet wide, and the average pickup truck is 6.5 feet wide. So you just figure it out. There is no way for two vehicles to pass back and forth. Now, having said that, the road has served us well. I mean, it needs probably new asphalting as time goes on, but it's wide enough to sustain the amount of people, the single-family houses that are there now, and the properties that aren't developed are in conservation protection. So that whole neighborhood is pretty much developed out. It's not going to expand any more than it is. So I'm comfortable with the road as it is for single-family houses, but put a commercial venture there, you're changing the whole dynamics, and that should be a burden. If this goes anywhere, at the minimum, that the applicant would have to assume. But definitely as it is, with the increased traffic, especially when the big party event happened in the summertime with the tents, the trucks with the tents, and everybody who parked up and down the road, we could barely get our cars out of there. Again, by having the owners not there, they're leaving it up to the property owners to be the policemen, to police when these things happen. And as I said before, you know, whenever there's an event, something going on with your neighbor, you're going to wait till the very last minute before you're going to call the police, because nobody wants to call them right away. So you got to tolerate it until you get frustrated enough to call the police. And this isn't something we want in our neighborhood.
Thank you.
I'm Chris Freed. I live on the hill, and I agree with what Bill and Elise said about the original. When you come up the driveway, it's very steep. I mean, it didn't show it that well in that picture, but it's really steep. And if another car is coming the other way, there's no way two cars are going to pass on. They say that doesn't really show the steepness of that. But when I read here, too, it said that we would put in our lease that any cars in excess of 10 cars would be, we would put it in the lease, they'd have to be towed. It's just unfathomable to picture 10 cars coming and going from this establishment on the bottom of the hill. And I'll just tell you a little story. I had a friend in Virginia, and she was on a similar road, a private road, and came around a blind corner and hit head-on with a truck coming the other way. She was disfigured for life. Her son had a broken leg. And it's just a dangerous situation if you put a lot of temporary people who don't respect the hill, and now you have to drive on the hill. It's worrisome, you know. Thank you.
Thank you. Is there anyone else who wishes to speak? Thoughts from board members? I have a lot of comments from our last meeting, a lot of concerns relative to this project. Liz?
I have one comment on the safety feature. I don't know about the rest of you, but I've been picturing this road in the daytime. I think we all need to think about the road at the nighttime. And if you are coming down that road and have to back up to let somebody else go by, if you're not super familiar with the road, let's say a truck isn't super familiar with the road, it's a pretty dangerous situation, particularly where the road gets steep and there's an embankment on one side. I'm assuming there are no lights. There's not even any ground lights on this road. Haven't been there at night. So you're in the dark and you're backing up or you're trying to pass another car. And I think that's another aspect we need to think about.
For Peter, we've heard it called commercial use a few times.
Sorry, it won't pick up. Thank you.
Commercial use, technically it's not defined as a commercial use with this switch, is it?
No, it's
Okay.
not.
go ahead.
No, that's all. I know we heard it, and I didn't know if I missed something, it's obviously not getting reclassified.
Right, and actually, I think there's one other area that's good to keep in mind. So this application that's before you, it's about the household restriction in your zoning ordinance, which says a household shall consist of no more than 3 unrelated people, or as many people as they can that are related, unless they get a special use permit, and then they can increase the household to more than 3 unrelated people. The reason that is important is because there is a case out of the Superior Court out of Barrington, where RISD owned a house in Barrington, and they were using it exclusively for short-term rentals. The zoning official said, you need to comply with the household restriction when you rent it. They appealed and said that they did not, and the court agreed, saying that a short-term rental, because it's a transitory use, did not have to comply with the household restriction at all in a zoning ordinance, unless it was specific to short-term rentals, which South Kingston isn't. So that's not controlling precedent. It is out there, though, so it could be persuasive to another judge if the issue bubbled up again. So, it is important to keep in mind, you're here on an application to increase the household. This will allow them, if they wanted to have the college student rental, they would need that. But it does present an opportunity for the board to impose restrictions on the special use permit, or to recommend restrictions that you otherwise may not be able to apply if this was strictly a short-term rental use. So in that sense, you do have an opportunity here to mitigate the use that you might not otherwise have.
And then just another question about, there's a few people talking about, like, who's going to maintain the road, the cost of the road. That's pretty much a private matter, and it's not anything to do with us, correct?
It is a private matter. In one question, Susan, you asked earlier, what's the procedure if a tenant was to block the road? And I think a comment from the applicant was that police could be called. They don't ticket private roads. That's a private matter. You can, if you have an agreement between the neighbors about who could get towed, they can come to that agreement. I would say that this is an opportunity, because if you find as a board that the impact of increasing the household limit to allow the college student type rental is going to impact a private road, you can ask that they take certain steps to address that impact and impose that as a condition. Of course, anytime you impose a condition, it needs to be reasonably related to the actual impact and bear a nexus to what they're asking for. But if you meet those two requirements of having a nexus and being roughly proportional, you can ask them to impose certain conditions that are focused on the impact on the roadway.
I got one more.
Sure.
And then those conditions, say if it did get approved or denied or whatever, but if it got approved and there were conditions added to it, just a clarifying question, those only relate to the winter rental. It would not relate to the short-term rental, or is that an opportunity to add restraint or conditions that would roll over to the short-term rental piece?
I could envision some types of conditions, which are just by the nature of them, are going to have impact on both. For instance, if you say you need to create additional parking space, and I'm not saying that's what you need here, but let's just say it is. Well, once that's built, it's going to be there for the summer rentals and the winter rentals. If you need to provide a turnaround or whatever it is, well, that's going to be there. But it is important to keep in mind that the impacts that you're looking to mitigate with the conditions need to come from the request to increase the household.
So, Peter, I understand, I think, your argument that it's a single-family residence, and they're asking for it within the zoning regulations for a single-family residence as far as just increasing it. I still have concern on at what point does it possibly change into a different land use. We heard testimony on the last month's meeting that it could potentially be up to 8 bedrooms. And at what point does it start looking at maybe something else that's in the land use, such as maybe a boarding house, where there's fire protection required because of the transient nature and there being, so many people living there. So I still have some concerns. Just the fact that it's a single family and they're asking for something under that. I mean, if I ask for a gas pump at my house, but I'm doing it under the single family, does that, at some point you say, well, that looks like a gas station. Doesn't look like a single family residence. So I still have concern on whether we're changing the land use and some of the safety regulations that would go along with perhaps that new land use that's not under a single family. I would hate to see somewhere down the road there be a fire or somebody get hurt, and the courts determine, well, that wasn't really a single family, that was a room and board house, and the town shouldn't have allowed that, and if they did allow it, they should have required fire protection. So these are my concerns.
So when you're at the zoning board, I usually have the building official sitting right next to me, so if I speak out of turn, he would correct me. Unfortunately, he's not here. That there are occupancy limits. I believe under the building code, there's a limit of something like one person for every 200 square feet. So then there's the septic system occupancy limit, which they couldn't exceed. Then there'd be whatever you set at the special use permit. You could set it at, leave it at 3, you could set it at 4, set it at 5. That would be another occupancy limit. But as far as a single-family residence, which this is, you could change the use if you were having locks on each bedroom and renting by the room to individuals. I think that would be more like a rooming house type of use. But, if you were to rent to a large family, my grandfather's family, they had 12 or 13 kids. It's not common nowadays, but theoretically, if someone was to buy that house and have 13 kids, they could all live in that house, and there wouldn't be any issues with the use. So I think there are occupancy limits. So there are limits that you can impose on the occupancy. If there's septic, it would be the septic. The outer limit set by the building code, whatever limit you choose in granting a special use permit on the household under zoning. But I don't think it would change the character of the use.
So a reasonable condition of approval then would be that they only have one lease and lease to one party, even though that party may have unrelated people, but they could not lease individually to 5 or 6 or 8 college students. If we required one lease, one party, not have individual necessarily, I hate to say non-individual locks because I think that's a reasonable thing to have in individual locks, truthfully, but.
Yeah. That's certainly something you can consider because now they can structure it in a way where they say, okay, you're responsible. You have to gather the rent from all the other students and give it to us. But if they're renting it with that one lease, then it fits within the, but I think you're right. It does change a little bit if you're saying, I'm renting this space to you in the house and that's yours. I'm renting this space to you in the house and that's yours. Now it does change it a little bit. It's not really designed like a dormitory-like type use or a rooming house use, but it is kind of changing the use towards that. The floor layout isn't designed that way, obviously, but I think that is a condition you can consider.
Other thoughts, comments, Susan?
So if we approve this application, can there be some sort of renewal in place so that at some point in time we could revisit how it's coming along?
Actually, that's a good point, because right in the ordinance, even if you weren't to put that as a condition, it says that this special use permit to increase the number only lasts for 3 years, at which case they'd have to reapply within 3 years. And one caveat to that, there is a bill now that would increase the minimum from 3 to 4. So if, let's say you granted a special use permit for 4 and that bill passed,
So 4 people or 4 years?
I'm sorry, 4 unrelated people. There's
I thought it was 5.
Is it 5?
I think the bill is 5.
Oh, I'm sorry. It might be, it's probably 5. But in any event, putting all that aside, since that's not the law now, assuming that the law stays what it is for 3 years, they will need to reapply 3 years from now. And of course, the neighbors would get notice, and if there aren't being good neighbors within that time frame, they can let the board know, and the board can take that into consideration of whether they're gonna grant another special use permit.
Peter, you may want to explain that this is advisory DPR to the zoning board right currently, because they applied before the regulations.
Right.
came into effect.
So Jamie was just reminding me, right now, you're sitting in an advisory opinion, you're giving an advisory opinion to the zoning board on a special use permit, because they applied prior to January 1st. If, when they come back, if it was granted, they would just come to the planning board for unified development review.
Yep.
So you would both hear the DPR and the special use permit. Notice would go out to the neighbors about this meeting, and you could take the concerns of the neighbors in, making the final decision. Do we grant the special use permit again, or do we not?
Okay, so one more question for clarification.
Sure.
The special use permit would apply to unrelated academic students living in the house during the winter. Is this also a renewable for the summer use, which is also unrelated but is a different category? Is that also then renewed at some point in time, or is that part of it, like separate? Is that, how do they relate to each other, and are they both renewable or endable after 3 years?
Just before council answers the legal part of that, I think what it's clear to understand is that they're asking for, and again, that I would like clarity from the applicant, because their application still says 6, yet the new information that they submitted says there's only 5 parking spaces for the lease. So I'm not sure how you rent to 6 individuals with only 5 parking spaces, so something potentially needs to change. But with respect to that, their special use permit is about cohabitation of more than 3 unrelated people. It's not for just 4 months, 5 months, 6 months, 7 months. The approval would potentially allow them to do a 12-month rental of the property to more than 3 unrelated individuals. So.
Robin?
Robin, can you turn your mic on, please? Thank you.
In terms of narrow driveways in South Kingstown, there are some, and they have very little traffic, not the flow of rentals and their guests. So I think that was a poor analogy. Yes, we do have some one-way driveways, but very, very little traffic with people who expect and know what to do when they encounter someone else. In terms of the history of the house being built in the 1950s, very few families had more than 1 car in the 1950s. And college students have a lot of visitors. They will not just be 5 college kids in that building. Furthermore, when I come up the driveway, as soon as I get to pretty much your first driveway, I can look right down to the water. So there's no big long walk or dangerous drop to the water for college kids for sure. I could have run down there myself. But I would say that in the town's comprehensive plan, denying a zoning variance for this proposal is supported by several findings of fact. A, the proposed use of the property encroaches upon protected wetlands, which is conflicting with the town's plan to safeguard such areas, particularly with respect to the increase in runoff from the property and the potential for pollution in Wash Pond, harming wildlife habitat and water supply to neighboring homes. Some other homes might be drinking that water still, as we all know. Denying the zoning variance would bolster compliance with stormwater regulations and protect water quality, as emphasized in the comprehensive plan. Any cars parking there, any dirt from those cars is going to run down that hill. B, excessive traffic impact on the single-lane driveway accessing those homes on the hill is a concern. C, there could be a negative impact on the historic preservation of the Hale House if If a kid leaves that road and goes down that hill, they're going to be in the Hale House. D, the denial will uphold zoning standards and preserve the integrity of surrounding neighboring properties, consistent with the comprehensive plan goal for orderly development. Student rental and summer vacationers do not align with the established character of that neighborhood. E, as part of this board's purpose, we have listened to community members who have brought to light previous problems with the clientele hosting large, noisy parties and parking problems that are not easy to control. F, the fact that the property is already occupied by more than 3 unrelated persons demonstrates a lack of adherence to the town's zoning ordinance and fails to suggest any hope of it in the future. These reasons, grounded in the South Kingston Comprehensive Plan, provide a framework for denying a favorable recommendation to our zoning board for the Commodore Manor proposal.
Thanks, Robin. I have a suggestion. Obviously, this is a complicated project with many concerns. Wondering if board members think it might be helpful for us to put this issue to a work session with legal counsel, with information that I believe we had asked for. Joe, you may have asked for a letter from the zoning official to help clarify what considerations we have and the necessary checks and balances that we might need to ensure occur and what options we might have. So that whatever decision is made is well thought out with regard to not only this decision, but future decisions relative to this type of application. Thoughts about doing that rather than making a rather hasty decision this evening without the benefit of a full sort of legal conversation?
Well, I'm not against that idea, but I think that it's our very important duty to protect that neighborhood and those people who live there. And granting this exorbitant increase in the use of that property, I think is nothing we should be supporting.
Liz?
I support the idea of meeting in a work session, and primarily because not just for this project, even though I think there are a number of issues we need to address, but I think the precedence that it sets. It's been an issue that's come before this board numerous times about student rentals and vacation rentals in various forms and various scales and various neighborhoods. And we know it's not going to decrease, it's only going to increase. And it does impact every community in a different way. So I think we've got the precedent issue here that we need to address.
Thanks. Other thoughts? Yes, we do. Susan?
I just wanted to say, Robin, I absolutely hear your concerns, but I also agree with Liz that I think that we need to really maybe button down some policy here before we move forward with a dangerous precedent or with a decision that could be appealed to our disadvantage.
Madam Chair, if I may.
Yes, Jamie.
Just, I understand, based on the commentation tonight, what you may be trying to accomplish, and I may offer a slight alternative to the work session. There's a lot of testimony both by the public and a lot of questions and concerns by the planning board members. And a number of those concerns are going to be complicated by what your existing regulations say and how some of those regulatory aspects are interpreted from a legal standpoint. So it may be best to position the framework of this conversation to refer the matter to legal counsel, to formulate perhaps a draft motion in a manner to incorporate all of your concerns as it would relate to how would you be able to move forward in a favorable manner with, we'll say, whether it's 10 conditions, 20 conditions, or 50 conditions, but let legal go through the testimony that's in place and see if there is a way from a regulatory stance to see what your regulations allow you to do. And if you go through that exercise, you may find that there are still items that either aren't addressable under the regulations that you still don't feel comfortable with, which potentially could be grounds for an alternative view on the application. There were also some references made to the comprehensive community plan and some aspect that is much less regulatory than your actual planning regulations and your zoning regulations. So there may be some well-intended discussion that may or may not be backed on the regulatory side. So I would feel much more comfortable to allow legal to give you some guidance on the regulatory side. I think Peter is well-versed in the fact that you're concerned about traffic, you're concerned about the width of the road, you're concerned about parking, you're concerned about the transient nature of the use, you're concerned about two aspects of the what has been coined as commercialization of the property, both as a student rental and potentially a short-term rental, but where the regulations allow you to fall on the regulatory side when evaluating an application. I think, Robin's touched upon some of those things. Liz, you expanded on some of those things. And I think there's some concern by the planning board members of exactly where your authority lies with this particular application as it relates to your authority under the regulations. And understanding you're making a recommendation to the zoning board, who actually has final approval powers, but in any recommendation you're making to the zoning board, I think a lot of it's going to fall down on what's your legal authority under the regulations.
Thanks, Jamie. And to the points that were raised by many of the board members, Robin, Liz, Susan, we need to make a finding that the granting of this approval will not result in conditions inimical to public health, safety, and welfare, along with the fact that these plans are consistent with the comprehensive plan. So I do think we need to be aware of what our ability and authority is, and be sure that we keep in mind precedent setting and dot the i's and cross the t's as we come to a conclusion. Joe?
I think I'm at the same place where Jamie is, in that ultimately I see myself voting for a letter of favorable letter recommendation because they bought this as a single-family house and they're trying to apply within the regulations of a single-family house. Where I'm less certain is what are all those conditions of approval that we would recommend that it mitigates the concerns to the neighbors and stays clearly within that land use category. So I think that if we can get a motion which addresses all those concerns that were raised, as well as looks at other areas in the land use regulations that are close by, and clearly distinguish this and maybe future projects that we see as a single-family use versus something like a room and board and that those differences be included in the conditions of approval. So help us with not only this project, but future ones. But Peter did address most of my concerns. But again, it's more going to be about mitigation perhaps some of the things that the applicants are proposing need to be mitigated even further, or maybe not accepted the way they're being proposed. But the parking, the traffic, the differences between this and a boarding house and individual leases and individual locks. So we fully understand that.
And having this conversation at a work session would also allow us to potentially discuss when does this become a boarding house, rooming house? How would that, or could it apply to future applications such as this, first or the last application of this type? However, there are unique assets, or aspects rather, particularly to this site that need to be given consideration, which might differ from other applications. So is everyone in agreement that we will continue this to a work session? Yes?
Madam Chair, is it a work session or a continuation to your next meeting? Again, at work sessions, typically you have Andy Tights here versus Peter, and I don't know what Peter's availability. Is your intent to have it at your next regularly scheduled work session 2± weeks out?
I think it would be helpful to have it in a environment of a work session as opposed to a regular meeting. Certainly Andy Tights is very experienced in these matters, and it would give us, I think, more flexibility, as well as the fact if there's going to be a lengthy conversation, we don't want to put it at the end of a very full potential regular session that we know is inevitable at some point in time.
My question would be, is it a distinction between a work session with legal counsel and staff in regard to get an understanding of where exactly the boundaries are? Or is it a continuation of this a discussion on this specific application at the work session level? I'm just trying to get clarity myself.
Yeah.
But my thought that it was a discussion of what our abilities, authority, limitations might be with regard to this.
So I just, Madam Chair, if I may, I asked legal to weigh in on, we'll say, the administrative process. We're in public hearing session this evening. DPR doesn't have a time frame associated with it, but again, to defer this hearing to a work session while you still have a public hearing open, the decisions you make are supposed to be based on the public hearing record. So if you had a work session, that would be information being received outside of the public hearing process. So I just want legal to weigh in on how you could accomplish what you're discussing.
So I think you could do that. I think what you could do is leave the public hearing open. I would, you might tweak your work session slightly by allowing for some public comment at the work session. I'm not sure if you do that at your work sessions. I'm not usually there. Of course, Andy could be there and discuss these issues with you. So the one point I would ask to clarify is would the conversation just take place at the work session and then result in a motion that would later come at the subsequent session? So there's no expectation that legal counsel and the applicant would work together outside the work session. It would just be, okay, so what would happen is we'd go to the work session. You'd have some comment at the work session if there's anyone there that wants to comment. Andy would be available to answer any questions you have. Once you feel you have a better grasp of what you would like to do with the application, just continue it to the next regular session, and you can have a draft motion in advance.
Yep. I'm just going to ask for a point of clarity. If you continue this public hearing, you have to continue the public hearing to a time, date, place certain. And then if you do that for next month's meeting, aren't you really, if you allow public comment at the next work session, aren't you running another public hearing?
Yeah, I would essentially just continue the public hearing to the work session.
Okay.
It's
Okay. And technically, this is not listed as a public hearing, it's DPR, so.
It's not a public hearing.
Sorry, I'm one agenda item up, sorry.
Yeah, I can provide some clarity to that. This application is not requesting any waivers, which is typically the trigger for a public hearing. You're also not sitting as the body to approve the special use
Correct.
permit that they're requesting. That public hearing has to happen with the zoning board as the regulations prescribed prior to December 31st, or prior to January 1st.
So we're really just continuing this item, or DPR, to our work session.
Right, and the
And
clarity,
then we'll continue.
correct, yeah. The clarity that I was thinking of was, it kind of sounded like you wanted to have a discussion with the legal counsel about the boundaries as to how you guys could act in any application such as this that comes before you, not necessarily this specific one. So if it was this specific application, it would simply just be, we're going to continue the public hearing to the work session to continue the discussion and hopefully receive guidance from legal counsel about as to how to apply what the boundaries are for the planning board on this application and any application going forward.
If we're going to move this to another work session, I would, what Jamie was talking about of having Peter prepare, I would prefer to have that prepared so we can discuss it at that work session, so we're not losing more time if that's the case.
And I do think we wanted to have the conversation specific to this application as well, so that if we are working on developing some type of motion, we can do that and craft that properly as a result of the conversation at the work session, so that it is then well prepared for the following regular meeting. Does that make sense?
That makes sense. I guess the question I would have is, as part of that preparation, one thing that might factor into the calculus is what would the applicant agree to without contesting. So in the meantime, would you like us to reach out to the applicant and discuss what type of conditions they would be willing to propose, or should we just leave it more
I think
just
that's the whole
general?
intent of the work session, is to figure out what criteria, what conditions we think would be appropriate for a particular motion.
Okay.
And then the applicant obviously has the ability to respond one way or another.
Madam Chairman, again, I think to Joe's comment, I think it would be expeditious if council laid out the framework for a potential motion that you could either retract from or expand upon based on that work session discussion. But the framework is there for you based on the discussion to date.
As long as it provides the necessary flexibility for board members to add language, ask questions, and so
Absolutely.
on.
Yeah.
I think that's the main. Liz?
I'm confused. Are we talking now about continuing the public meeting, the regular work session, the regular session into a work session?
So, Madam Chair, just for clarity from an administrative side, your work sessions are typically non-application based. They're work session, more philosophical discussions. What the chair is recommending is that this agenda item be added to the work session meeting to allow you to continue this discussion in preparation for potential action at your regularly scheduled meeting at the end of April. It
And-
gives you it gives you an opportunity to discuss this more broader with draft language before you.
And although the conversation will be specific to this application and potential others in the future, it is an important policy issue that we are facing on a regular basis. So we need to have those conversations and figure out what we can do. Do we need to modify our regulations to better manage these types of applications? That's a necessary conversation which we should have, and that is sort of the norm in our work sessions, that we discuss policy issues.
Yeah, may I just
Yes,
add something
go
real quick? Two things. One, I think Peter would probably agree with me that in the term, we've heard the word precedent kind of utilized tonight a number of times. I don't believe that there truly is any precedent on certain applications or certain statements that were made. Precedent every property presents a unique situation. The way we handle things from a procedural standpoint is important, but the precedent of a decision or the precedent of private roads being utilized throughout town, there really is none. Private roads can and that's just a statement just to clarify, because I think it can lead to a little bit of confusion sometimes when people think, oh, we have to be worried about setting precedent on things. Well, if a certain approach is taken on one application, it was done because of a specific unique characteristic, most likely. And the other thing is I just want to recognize Robin's approach to her input. Not the content of it, but the procedure and how you got there. Utilizing the comp plan, utilizing statements that are quasi-regulatory is exactly the direction that boards responsible for making these type of land use decisions really need to do. You really need to dive down and get to the substance of what it says. Now, the problem with that is that by adopting the comp plan, our ordinances have to be in line with that as well. So the meat and potatoes of the regulation comes from the zoning ordinance, which is produced by the comp plan. So while the comp plan might say it, you really need to look down at the zoning ordinance and say, it should say it as well. It should provide the guidance. And at times when it doesn't, it gets kind of shaky, I think. I don't want to overstep my bounds, but I thought it was worthy of mentioning tonight because I was happy to see your approach and going and looking at it from that direction, and because that's exactly what boards that are responsible for making these type of decisions really need to do for a strong decision that is defendable. And I just thought it was worthy of recognizing that.
Thanks, Jay. Do we need a motion to continue this item to our work session?
It would be most appropriate if you entertain a motion to...
Would someone like to make that motion?
It's 4/9/2024 is your work session.
What was the date again?
April
April.
4th, 2024.
Jamie, I think you said April 9th?
4th, he said.
4th is a
Right.
Thursday, I
Oh.
think.
No, 4/9/2024.
Oh.
April 9th.
April 9th. Would someone like to make that motion?
I'll make that motion.
We have a motion from Joe to continue this item to our April 9th, 2024 work session. Do we have a second? Second from Peter. Any further discussion? All those in favor say aye. Aye. Was that an aye from you, Robin? Thank you. Motion carries. Our next agenda item is a recommendation to the Town Council, advisory zoning map and text amendment, Tidestorm LLC, proposed creation of a new commercial neighborhood.
Madam Chair, I believe Mr. Attorney Landry is here representing Tidestorm LLC. They have made some proposed amendments to their original submission, which I believe his intent is to go through those this evening. And again, I'd like to appreciate everyone's attention to this item because it was late on your agenda the last time we met, or a little bit earlier tonight.
Thank you. Good evening, Madam Chair, members of the board. Attorney Matthew Landry on behalf of Tidestorm LLC, my client Kevin Finnegan. I'll keep this fairly brief. I know we've discussed this over a couple of meetings. I did make a supplemental submission to the planning office on, I think it was March 18th, just updating and revising some of the package materials that were submitted to reflect some of the discussions and some of the changes that we went over the last 2 or 3 meetings. I'll highlight those. I'm not sure if you have a hard copy of that submission. I imagine you received it electronically. I do have hard copies. If anybody would like a copy, I'm happy to pass those out. One addition to that package is a traffic supplement that I did submit electronically, but did not submit in hard copy form from PAR Engineering. I had indicated that we were working with John Shevlin at PAR to provide a just supplemental traffic statement as to what the impacts may be of this use in rezoning these lots. I'm not sure if that made it into your package, but I'll hand those out as well.
Yes, thank you.
And while those are being passed out, I'll just kind of highlight the change to the package. The March 18th submission is very basic and straightforward. Nothing drastic has changed. Really three primary changes. One is that we revised the lots that are being proposed for amendment to reflect only those lots that are zoned CN. I know there was some questions about some lots being zoned residential, and we captured some of those lots either directly or inadvertently. So I updated the package and the narrative that was attached to it to reflect the actual lots that are being, the removal of at least 12 lots that were either CN or residentially zoned. Just making that change as we discussed at the last meeting. The map that you're looking at is also a supplemental map to reflect that change, the removal of those residential lots. So you'll see that the zone has shrunk a little bit. And the really most significant change is we removed one of the CN and residentially zoned lots, 93-1-1. That's 25 Barney Road. That's the much bigger lot that has a lot of wetlands that extends off of Barney behind the existing pizza shop and goes pretty far north to where those new condominiums are being developed. You may recall that it's a split zone. The front portion of that is CN. The rear portion is R20. As Jay had indicated, I believe it's the preference to rezone the entire lot and not only a portion of the lot, and we certainly had no objection to that. The lot immediately to the, if that's the north or to the left of that on Barney, we've kept in. That one also is zoned, is a split zone. That's also CN and R20. Our intent is to rezone the entirety of that lot. It's a much smaller lot. The problem with the larger one, 93-1-1, even though most of that lot you can't build on because it's wet, it would rezone a large portion of that lot into CN, potentially impacting and raising concern of a number of those abutters. So, you know, we just removed it. We felt no need to complicate matters and remove that. So that's the only significant change, I think, from this map. So we removed that entirely. And just kept all the remaining lots CN zone. There are no residentially zoned lots as part of this submission. So the supplemental submission on March 18th was really just to clarify that and list the appropriate lots. We've also clarified the list of uses that will be contained in this amendment. There was some ambiguity over what uses were being proposed that exist currently in the CN zone as to what's being proposed. We just clarified that list to keep everything that's already allowed in the CN zone and not change it. We had removed a couple of those uses that probably wouldn't be allowed anyway because of their proximity to restaurants with alcohol use and things like that. But we just kept it the way it is now, so there's no significant change, and we clarified that list. But that list of permissible uses, either by right and special use, are already permitted in the CN zone, so there's no change there. And again, we removed the residentially zoned parcels from this proposal. So no uses that are currently allowed in the residential use will be impacted. So the only uses that are being added are the accessory uses that are being proposed as part of this. We also added in red, or you should have it in red in the narrative, a very brief operational summary. Some of the questions that were raised over the last two meetings had to do with, say, hours of operation, deliveries, the types of trucks. This isn't numbered, but it's the third to last page under narrative. Tried to highlight that in red. It talks about deliveries, when those should occur, ample space for storage, raw material storage. I think it was Jay or Jamie had suggested that it's sort of like a big bag of cat food, or I'm not sure what the analogy was they used, but that's correct. I mean, it's real. We're not talking about large, significant semi-trucks delivering product. These are very small deliveries, typical box trucks, and there's ample room to turn around in that lot. And with respect to the fermentation process, we just tried to provide a very brief description of what that will be. We don't want to get into the full science of it. But the byproduct of this operation can be trucked off only once or twice a month. We could contemplate being necessary, and then that can be taken to local farms and utilized in their process and recycled as part of the process. So those are the only changes. The substance remains the same. Again, it's removing the residential lots entirely from this zoning proposal. We think that minimizes even further the impacts of the amendment, isolates it to the commercially zoned properties. It's consistent with existing uses. That's all I had to add. I'm happy to answer any questions. My client's here as well to answer any questions you may have.
Thank you. I do have a couple of initial questions. The first one is in the newly designated zone, how many lots are not owned by the applicant?
That's a good question. Most of them are owned by my client. Trying to think, I could ask my client, do you know? Hey, come up here. Yeah. Just approximately how many lots that you do not own that are part of this?
Just state your name for the record so that we pick it up.
My name's Kevin Finnegan.
Thanks.
The town lot that we're been involved with to the west. On the ocean side, it would be, I think, 3 houses.
Okay.
And on the other side, it would be 1 house or 2.
Okay,
So the rest are, yep.
okay. Thanks. All right, and then I know that there'd been some references to branding and, consistency with the feeling that embodies the village of Matunic. And I certainly support your effort to establish a brew pub brewery. It will be very popular, as I'm sure you can imagine. However, have you thought a little bit about, both in terms of branding, utilizing a little different architectural element than the shipping container, and also considering how, given the location, it can be as climate resilient as possible?
Yeah, I could let Kevin speak to some of the options. I know we've looked at a number of options. That there's a lot of opportunity out there to put these in different types of structures, and obviously being in a coastal zone, that's obviously of concern, and we are cognizant of that. We want to be environmentally friendly as well. When we initially brought this to Jamie and Jay over a year ago, I think it was, we had originally contemplated moving a garage on the abutting property, picking it up and moving it to this parcel. I think it's 300 or 400 square feet in size. That brings with it a number of its own complications and concerns. So the alternative was some sort of mobile storage container, similar to what's already on the property today. If it's on wheels, there's different ways that you can address FEMA concerns, floodplain regulations, and things of that nature. But I think the mobile nature and the temporary nature of it, was one of the interests. But I don't know if you've considered other options. You want to comment on that?
The use is the most important thing. If it grew could you put a permanent post and beam, make it look better? I think that would be down the road if necessary, but it's really just the branding. Anything that grows from this is gonna get brewed off premise someplace else. So I'd like to be almost more nondescript in Matunic. What's there is there. You kind of don't notice the container in a way. It's if you build something, I think it might be nicer, but I think it'd be more, visible. And so it's kind of like a brew the beer in a container, self-contained. It can be taken away in a storm, stuff like that, because you have equipment in it, type of thing.
It's also kind of a modern development too, from what we've found, is that a lot of newer breweries are found in these shipping type containers. It seems it is somewhat more of a modern design, and it can be fully contained within a shipping container that's only 300 square feet, but certainly considering all the options.
Yeah, and you wouldn't want it to be a hazard in a storm either.
Right.
Thoughts from planning board members?
Just out of curiosity, your fermentation byproduct, So, I love the idea of it going to farmers, but does the town have like a chain of custody regulatory thing in place?
I'm not aware of one.
No, for something like that, there wouldn't be any requirement for that. I mean, wouldn't be any different than material for composting that was not brew-related.
The operational process is obviously regulated by the state. This is within CRMC's jurisdiction, so the byproduct and the waste will certainly have some oversight, and the methods that are utilized to dispose of any byproduct will be regulated, but...
CRMC would be regulating it, is that what you're saying?
Well, it depends on how it's stored. This is going to be an external, a very small tank that the
I
product goes into.
recognize it's small. I'm just curious as to
Yeah, no, I'm
how
not
do we
aware.
deal with this?
Yeah, I'm not aware of any. I think it's not a hazardous product. It's coveted by farms and utilized or whatnot. So I don't think it's that terribly regulated.
Right, you don't want it in fresh water, say, or salt water for that matter.
Yeah. So no, I don't think the town has any jurisdiction. It's within CRMC's purview. I don't think they have anything that would specifically regulate this. It's not like discharge into the groundwater or anything like that. So.
Mm-hmm. And so it must have to do with the size of your operation. Right. What if you got to a certain size?
If you upscale, like at most other, that you have the Brewers Guild in Pawtucket, you have, out of state, in state. You can brew it if it gets bigger, whether it's waste product or actual product. I have no intentions to grow up from a certain scale that we're,
At that location, yeah. Right.
Yeah, I think we'd be pretty clear too, and just to clarify that any upscaling of this operation would be done off-site. It wouldn't be done here. This is really just the birthplace of the product.
I think it's a pretty exciting project, yeah.
Susan?
I have a couple of questions. So can I just clarify our process here? At this point, we are reviewing a change of zoning regulations. If this project were to move forward, we would then see something back to approve whatever's being put in? Or does this, because it's not a special use permit, basically just grant a by right installation of this kind of project?
So so what the process now is, you're giving a recommendation to the council on consistency with the comp plan, consistency with the purposes of zoning. It would then go to the council for a public hearing. They'd have to advertise it in the paper and all that. Assuming it passes, if it passes as a permitted use, then they could build by right, assuming that they don't require any variances and that there's nothing added that requires development plan review. If it's passed that either requires development plan review and or requires a special use permit, then it would have a second round of review after the ordinance passes, where they'd have to then file their application, get complete application materials in, and that would let either the planning board or the zoning board review it.
So you're saying that a zone change can be conditioned?
Yep, you could condition it, or you could make a text amendment and just put this use into the use table, and instead of a P, put an S, and then have the standards.
Okay, so thank you. So my question for you, it's my understanding that you've talked about a small garage-like building or a shipping container. Could you, for me, just sort of clarify exactly what a shipping container is? Is it the thing I think it is, or has it been retrofitted, or is it up on stilts, or what exactly is a shipping container that you would use for this purpose?
The pictures, we sent you some pictures, a basic shipping container, everything's fitted inside. It can be on stilts or on wheels. We've been talking about that. I think wheels are the more helpful, but it's just parked there just like the other one is, a shipping container that you would consider a shipping container, there's no,
Like the one they see on the news falling off the cargo vessel in
the
the
cargo
Atlantic.
vessel that just
Like
hit the bridge.
It's just a rusted,
All of those shipping containers.
Not good timing.
Not that this is going to fall off some barge. So how much of this land that we are proposing is subject to getting really wet when we get those big old storms down there?
It's probably the highest, it's never been wet.
Okay.
It's the highest, as far as my property, it's the highest point, of all the properties.
So like the surf shop area hasn't been inundated during these floods we've had?
In my history of my life, even the low pots in the back, rainwater, I don't think ocean water has ever been on that side of the street. I don't think it has been.
Okay.
It definitely, surf shop, where that shop is the highest point of the domination of, what you mentioned that, I didn't mean that, but like that section of land that we own, stuff like that, so.
Thank you.
Other comments? Joe?
I'll just say that, I'm supportive. I mean, I think that the operation they're proposing is truthfully minimal. The impacts are minimal. They're leveraging the Matunic reputation, which I think is great. And I hope that when you do scale, you stay close enough to create local jobs. And I hope the product is good enough taste that we're all proud. So that's it.
Anyone else?
If I may just interject, Madam Chair, too, in terms of coming back to the board, if this were to get approved by the council, there's a couple of moving parts with this that I'll probably have to work with Peter on if it does move forward. This is being proposed as an accessory use to a restaurant with alcohol, and that use is only allowed by special use permit. So there is a question of whether or not this could be accessory by right, or whether or not we would have to come back and amend the existing special use permit that my client has for the pizza shop to reflect this. So the situating the containers on the property, whether or not if it's on the ground requires a foundation, hurricane ties. There's a lot of things at play there that may trigger development plan review that we're still working through when we present you with a conceptual plan. So it is very possible that we'll still have to come back before you.
I'm sure we'd be happier with that situation.
Understood.
Yeah,
Jake?
again, Madam Chair, just as a follow-up to Attorney Landry's comments, and again, it may need additional discussion with council, but to Mr. Murphy's point, he asked to, and Susan Axelrod's point about the permitting process, there is the potential that, as written, if it's an accessory use to a building that's already approved, it's potentially a zoning permit. So there's no limitation on the size of the container contained in the regulations. There's only a limitation on the size of the amount of equipment in it. I know the terminology was used as a 5 and 10 barrel system, but I believe the regulations allow up to 35 barrels system. So there's some clarity we need on our side with the applicant's legal team as far as what the final intent is. Again, if there's concern about a seat container, if you don't put those concerns and articulate them through a code, then I think you're hard pressed to say when an application comes in for a seat container containing a brewery, you have no regulatory stance to say no to that. So, we've heard testimony that I may do a post and beam building. Well, if you don't have it on a regulatory side that it actually requires that type of infrastructure or investment, there's nothing from a regulatory side to say the applicant proposed a seat container. It's actually 2 seat containers latched together with a door cut between the two. As long as it meets the dimensional code, they should get their approvals. So I think my concern in the discussion I hear tonight is if you're looking for some additional regulatory controls to try and articulate them so Mr. Landry can discuss those potential controls with his applicant and make any potential revisions based on that discussion. But just understand right now, it's a list of uses that fall back on the dimensional codes existing in the regulations. There are no architectural standards. There's no primary landscaping standards associated with the dropping of we'll say a box on this site.
So
And
Jamie,
I'm not saying it's the applicant's intent not to do any
Right,
of those. It's just, if pressed, what do the regulations require them to do?
We did, if I may, we did put a limitation on the size in the proposed ordinance. We put a 1,500 square foot footprint size, but we also added a provision there to to try to address that, because it's not our intent to do a very large operation here, obviously. We put a limitation in there that it's limited in size to 1,500 square feet, but at no time could it be any larger than the principal structure. So it has to be incidental and subordinate to whatever the principal structure is, which is typical for accessory structures, as you know.
right.
And the existing structure on that property, the pizza shop, surf shop, I don't know what the square footage is. Is that
So
1,000?
it could be 3 or 4 seat containers at that square footage.
It can't be, well, the square footage couldn't be larger than what already exists on the property.
So
It couldn't be larger than the principal structure, which I don't know the number offhand.
seat containers roughly in the 600 square foot realm.
The typical, the shipping container that's proposed is 320 square feet.
Sorry, is that footprint, or is that something that can be stacked?
That's the footprint and the size of the container. It's
footprint.
320 square feet.
But
That's
if,
correct.
let's just say we limited it to 320 square feet, can you stack two and call it, like, is it the footprint foundation that we're talking about, or is it the totality of its size?
The way we've written this, it says accessory brewery and brew pub shall be limited to 1,500 square feet in size to accommodate all the necessary equipment. So the way I read that is the size, not necessarily the footprint.
Yeah, I think that would have to be clarified, because generally in zoning, when you say square feet, you're referring to a footprint. You know, if you were to refer to the size, that would probably have cubic feet.
Yeah, but isn't there like accessory height that it
But
can only go to? I
it
mean,
would
there's
be
a lot of
subject to
code
the
around
height.
this. Yeah.
That's right, it'd be subject to the height restriction. So I think the way I would read that would be the 1,500 square foot would be the footprint, and then the height restriction would limit how high it could go, and then that would be the total size.
Yeah, I think it's 20 feet, an accessory structure on a piece of property. And then someone mentioned it has to be smaller than the existing building there. Is that
The
true?
existing building's 1,540 square feet.
So it needs to be less than that.
So if again, I don't want to dive too deep in the weeds, but it's just understanding, and this zone change and text amendment goes with the zone. The property exists within the zone. The language and zone will exist long after people in the room will be around. So it's just a clear understanding of what potentially could be built here. So if the first floor area is 1,270 square feet, and then there's an enclosed porch and some patio area. So we'll just take the building of first floor at 1,270 square feet. The way it's written is the accessory use of a brewery could be up to 1,270 square feet. So if you're looking at a short shipping box of 300 to 400 square feet, you could do those multiple times up to that 1,200 square feet.
Right, but it still has to meet all the building code that's there and the lot coverage and all the other things, correct?
Correct, but just
Yeah.
understand if you have no provision against a shipping container, that they could do 4 or 5 shipping containers on the property. And
I mean,
again,
he
it
could
may
do that-
not be
He could do that today. Don't put beer in it, but he could do that today, right?
I'm not clear on that regulatory ability today.
I mean, I think what's in the box is what changes this thing, but if he had that 1,500 square feet of boxes there now that were surfboards or skateboards or something else, it wouldn't matter.
So from my perspective, it's just understanding clearly what the intent is. If the intent is never to do a brewery in excess of, we'll use the term 500 square feet, then the regulations, in my view, should be clearly stated that the accessory for a brewery shall not exceed 500 square feet for the brew operation.
Yeah, sure. I think what I heard was if this works and they make money, it becomes a nicer box and may grow a little bit and things like that. So I think there should be some flexibility on that. But I do know that there's a lot of code that protects stuff there now, building code.
So Jamie, could you explain what you meant when you referred to controls with regard to this. I mean,
So,
obviously, we support the use, we understand it's accessory,
And again, I
but
think
there are design considerations, so
There's
to
been a
speak.
good conversation about the use, and I haven't heard any pushback on the potential use of the property as accessory brewery to an existing restaurant. If you recall, if it kicks to a special use category, the change in the legislation was very specific, that as you evaluate a special use permit, you have to evaluate it against very specific criteria contained in your regulations, and if your regulations are devoid of that, it really becomes a permitted use as of right, not a special use permit. What I'm saying to you tonight is there really are no special conditions associated with any, if you move this to the special use category, what are the special provisions? The regulations don't contain any right now. So I guess the challenge is to have the applicant potentially work with staff, and if their intent is only to get so big, then limit the size, to Peter's point, give flexibility, but also better define how big the operation can get, what type and what the operation will look like. And then those are some of your, does it need to be screened from, and again, your rezoning area, so there isn't an abutting residential zone anymore, does it need to be screened from anything? Right now, there would be no screening because you're not abutting a residential use because they're changing the zone that used to be residential behind here. So it's just a clear understanding of what is intended to be built on the site. Do the regulations articulate that clearly? And are your expectations of the final built product articulated through the regulatory controls? And again, my discussions with the applicant have been that, they intend to do something very Matunic-like. They understand there may be some additional controls, and I haven't had conversations about pushback from that. It's just being able to accomplish the use and the provisions that go along with it.
It seems as though having that conversation with staff would be important, useful for us. Again, I guess branding and design is in the eye of the beholder, but I would think that having multiple shipping containers would be the best design in terms of either aesthetics or resilience, so.
Can I ask a question about shipping containers?
Yeah, go ahead.
Could I ask, I'm sorry, I'm asking again about shipping containers. This is making me a little bit uncomfortable. So are you choosing a shipping container because it's the perfect size, weight, and structure for what you're doing? Or are you choosing it because it's an inexpensive thing to install that will give you a jump start? And for example, if you really like the shipping container because of its usefulness, if we asked you to disguise it in some way, God, there's so much reverb on this thing.
It's Jay.
If we asked you to disguise that in some skim of something more appropriate to the neighborhood, would that, I guess I'm not understanding the purpose, why you would choose a shipping container. I'm not challenging you, I'm just asking for it to be educated. And then what if we didn't want it to look like a shipping container?
I mean, ideally, someday, if it's successful to the scale that we want, it's getting brewed off-site, just like anything in your house, or, you would improve the look of that thing, or, come back and put something prettier or more appropriate, or, I think it's appropriate right now in the way the village is.
Yeah.
But tomorrow it might be like, hey, let's put a post and beam, or let's put a little shed. I've been to tiny places, half the size of behind you type of thing, so. But right now, the way Matunic looks, along with all the other properties, it'd be the simplest, easiest, way to do it, you know what I mean? And see if this whole thing works. If it works, I think you could, if it doesn't work, you could take it away a lot easier. If it does work, we can sit, I'd be happy to sit down and make things look better.
Right.
That's part of the zoning change too. We're gonna, you know, start, I mean, the Ocean Mist, I remodeled the inside, but I made it look like it did, but it's all brand new. Some things across the street, you'd like to, you know, reshingle, redo, rebuild, you know, keep the integrity or the shape of Matunic.
Yeah.
But right now, I think the shipping container is the simplest, easiest to grow with it or actually take it away if it doesn't work.
Right.
You know, type of thing. So, is that
Thank
good
you.
answer?
And the surf shop came in front of us years ago, right? And then we went over landscaping design, and I mean, we worked through, the surf shop is a shipping container, and we worked on that project, I don't know how long ago, but.
Very
Yes.
similar, Pete.
Yeah.
Very similar, you know, did I think in a million years I was gonna sell hats and t-shirts? You know, so basically, it was nice to be able to start in a cube and then a shipping container, and now we got a nice little shop next door that happens to be the building that was already there. So it, you know, I would take the same process, I think. If it didn't work, you wouldn't have that original shipping container that we worked towards years ago. It's a,
I understand the concept of simple and easy, I just am not a fan of the look, I guess. And thinking if there's something else that you could do, I mean, you mentioned the shingles and, you know, having the ability to change as you go forward, but something that's a little more in keeping with Matunic rather than, you sort of see those shipping containers in the super urban type environments nowadays.
you know,
And I know there's one that's there, but,
the limits that, you know, like I said, I don't want to go one shipping 2, 6, 10, 12.
Yep.
It's a shipping container neighborhood, no. I think it's a really appropriate use from, I've been there my whole life. It's, you know, just, you know, there's 1 or 2 on Carpenter's Farm, that's appropriate. There's 1 or 2 here, you know, there's certain places it's appropriate. I think this is an appropriate use and grow into like the surf shop would be the same pathway. You know, if it,
One more thing. So the only other thing I'd like to add is that you're not necessarily the only person who would take advantage of this new ordinance. And I love the Ocean Mist. It's the bomb. But your neighbor might not choose your path of how to manage his shipping container. So this ordinance would apply to all the properties that may have owners that don't have your same idea about, you know, start with this and go to that. So I think that's the hesitation, is that if every one of these properties put a bunch of shipping containers on it, it wouldn't be what it is now. And that's,
absolutely.
wait, and that's the risk, is not, it's not about you.
Yeah, no.
So yeah, so it's
That's
just,
how I've got along in that neighborhood for 40 years, is it's not about, you know, I try to work with those neighbors type of thing, so.
right. But yeah, this will apply after we're gone and you've retired and gone to Boca or wherever you go. And so this would carry on after you, so, yeah.
How can you limit that, or that's up to, you know?
Yeah, I mean, no, and we're sensitive to that. I think, you know, we've tried to evaluate a lot of different options, and again, this started with moving the garage, but anytime you're putting something permanent and a structure on the ground, you've got to go up above base flood elevation, hurricane ties. I mean, we went through all that originally with the original design for the surf shop before its inception. So this is a very, it's a smart solution now to try to navigate some of those hurdles, some of those issues, and it's an efficient way to get the operation going, to see if it will be successful. You know, and this is limited to accessory use for a restaurant, you know, with alcohol use, with a special use permit. Kevin's got control of most of those properties, and it's true that there may be another owner sometime down the future that may want to utilize this that's within that zone. But the reality is you've got to have a restaurant with alcohol, and there's very few, if any, parcels that you can do that or expand that on within this zone. But I think, you know, Kevin's certainly open to making it look more approachable and, you know, Matunic Lake. I don't think there's any aversion to that, and trying to dress it up, if you will.
Brought up you know, that same pathway, you know, maybe in 5 or 6 years, you know, the surf shop, you know, obviously sea level rise, things like that, raise it up, put it on stilts, change that building to something that, whatever the new, you know, appropriate thing is in the future. So you're not gonna, I think it's just a limited use for me, like it's just I don't see me, you know, going container after container. If you can limit that from your zoning thing or attorney-wise, I'm fine with that, you know, or making it look good, you know, just changing the color to gray to the one that, you know, nobody even knows it's there, you know, type of thing. And it, you know, that vibe of a old 65 Chevy and a container and a building, $1 million house and a trailer, all mixed up together. I think that is the character of Mattoonic, you know. I think if you had all trailers, all million-dollar houses, it wouldn't be Mattoonic with all those little bits and pieces make the chicken soup together, you know, so to speak.
Any other thoughts from board members? Anything from staff?
Yeah, Madam Chair, if I could just, couple of tidbits of knowledge. So the shipping containers are built in what's known as 20-foot equivalent units. So they're either 10, 20, or 40 feet long, and basically an 8x8 box. So they're all designed to lock together on the deck of a ship. So what they're describing is a 40-foot unit. You may want to consider, in addition to limiting square footage, you may want to consider limiting the number of units that could be cobbled together like Legos. And then from my experience working in Coventry, where we had quite a number of mobile home parks, yes, I agree, something long and skiddy and sitting on a truck chassis isn't the nicest looking thing, but in an area like this, it does have the advantage of being able to be moved out of the way of storms. If you were interested in trying to make it look nice, the trick they use with a lot of the mobile home parks is like a modesty panel around the undercarriage, so you don't have to see the rolling chassis sitting there underneath it. It does improve the looks a little bit, so things to consider.
Madam Chair, may I?
Yes.
I'm going to take a little different approach on this. We're considering the change to the zoning ordinance to allow for an accessory use as being proposed. And the shipping container discussion kind of came in as a way of telling the story as to how it's going to work. I don't have any problem with any of it. I just think going forward, we probably shouldn't be so, I would not recommend being so specific to look favorably on the zone change with shipping container, as so specific to be a shipping container. I think we should take the board of the town should take the accessory use component of it and focus on that. I think there could be a potential, now I don't know this for sure, but I think there could be a potential difficulty with interpretation of building code requirements and flood zone requirements. This property is in a coastal A zone. If you were to build a structure there, it would have to be elevated on piers or pilings 4 or 5 feet. There could be a discussion as to saying, well, it's a structure. It's accessory, but it's still a structure. Structures need to be elevated. So you're going to be forced to put it on piers or pilings, which complicates the matter of it being mobile or not mobile. There's also a question as to whether or not in a flood zone, if it's going to be secured in some manner or not, you know, or what the parameters are with it. If it truly is mobile, when does it have to come out? When does it doesn't? A lot of that is subject to interpretation by the building official. Every building official is different, right? If we lose our building official and a new one comes in, it could be an entirely different interpretation. So I generally tend to think that when we get down in the weeds on something as general as a zone change, that we shouldn't be, that we should look at the accessory use component of it and then rely on the development parameters that we put in place, whether it's development plan review or a special use permit, to specify the standards as to what it should be. Because we all agree that, I mean, let's assume that we all agree and this is a good thing and it's going to be recommended favorably. Well, if the applicant incurs issues in actually putting this on the ground or utilizing it, he's going to be hamstrung because he's stuck in a shipping container. And what if the shipping container doesn't work? And you say, well, gee, if I just could do a shed, well, that's not what the language says, but we would have been okay with a shed. So I kind of take a step back and say, let's look at the use primarily and then try to figure out the mechanism that through the regulatory process, we ensure that it's going to be what he wants and what we expect it to be. I just think it does lend to putting him in a corner, well, putting any applicant in the corner if they can't effectuate what they want to do because of something we don't know about.
Those are really good points, Jay. Thanks. All right, so you'll continue your discussion. Oh, is there anyone in the audience who is here who wishes to speak to this application? Okay, just checking. Thank you, we'll see you soon.
I would just comment too, I think the deadline right now is April 1st to make a decision. I don't know if we need to, at the last meeting, we had provided an extension to April 1st, assuming we would get a recommendation this evening. I don't know if we should discuss that or not.
So, to be clear, unlike the deadlines that you're usually familiar with for applications that are coming before you for major land developments or subdivisions, this is a directory deadline in that there's no penalty if you don't meet it, but it does set out that you should, or it says you shall, but there's no penalty if you don't meet it within so many days of receiving the application, give your recommendation to the council. So there's one of two ways you can approach that. Well, I guess there's multiple ways you could approach it. You could just not give a recommendation and just keep on working on it, and there's not going to be a repercussion. But ultimately, that could lead the applicant to go to the council and say, look, we want you to consider this now because the planning board took too long. Or you can take some more time, drill down, come back with something that's fleshed out that you can look at another time, and we can agree to do that. Or if the planning board is if the planning board wanted to, they could just say, look, we've looked at this to the extent we could. There's some open issues, and then just kind of leave the recommendation open-ended.
What would be the time frame for having the conversation with staff and the applicant so that we could move this forward?
When our schedules allow it, in the next week or so,
Okay.
we could accomplish that. Again, your next regularly scheduled meeting for regular session is April 23rd.
Would that be acceptable to you folks?
Yeah, let me just double check my schedule to make sure I'm here. Is it?
If Mr. Landry was away, the next meeting after that is May 28th.
I am conflicted on the 23rd. I'm going to be at a hearing in Westerly that evening.
May 28th? I know that's 2 months from now, but
I hate to say, let's add this to the work session and have something ready for the April meeting. And I don't know what you have planned for our work session, regardless what's on
so
our
you're saying
list.
look at the April,
Well, yeah, I mean, if you have the conversation and you come to some kind of agreement and we can make the decision about special use permit or DPR. and-
April 9th work session. We could try and accomplish that.
Yeah, we're happy to have that dialogue, certainly. So April 9th? Yep, that's fine.
I don't think this will be that complicated once you have the conversation and.
Yeah, no, we're
Figure
happy
out some of
to
the
work
details.
with council and the town.
Great.
It's certainly our intent. And to the extent you need an extension from us to accommodate that, we'll provide it to the town.
Super, thank
Okay.
you.
Thank you very much for your time.
Madam Chair, if I just have one more thing for the applicants. So I'm staff liaison to the Economic Development Committee. I do advise them of new commercial things that come up. I mentioned this at the last meeting. If you're interested in speaking to them, they are also advisory to council. I can see what I can do about getting you on an agenda just to speak with them, so feel free to reach out to me.
Okay, thank you very much. Appreciate that.
Next agenda item, TRC member for the April 10th meeting. You get to choose. All right, Peter at 9. Last item is discussion about meeting time, returning to 7 PM. Thoughts from folks? When we get into the warmer weather, 6 is challenging. And we've had a week of 6 o'clock meetings this week. Liz, Joe?
I'll go, I'm okay either way. I will say that 6 o'clock I am rushing to finish my work.
Joe, Mike, please.
I would just say that, I mean, I'll do it either way. I support it either way. 6 o'clock I am rushing to finish my workday and to go home, eat, shower, and come here, so.
I'm in the same situation.
Madam Chair, I am too, but, you know, I'll be here sometimes like 5 minutes later, just because, you know, picking up the kids and all that, but
What about 6:30? Is that any help?
I can stick with 6 because I want to go along and get along, but it's a pain. It's hard. It's hard to get out of work and stand over the sink gobbling a half a bagel to get out the door.
Is 6:30 a compromise?
I think it is.
I would do that. I'll go all day.
Are we saying just summer or? I get up at 5 in the morning.
Well, the last time we had this conversation, we decided not to do summer, winter, because when does that actually begin and end? Even though they're
Yeah, I agree.
astronomical data.
When Brickley's opens and closes.
6:30 seems like a little bit of a compromise that would certainly help. It would help me, would help you. Peter, does that add any
so,
usefulness?
I mean, if you don't mind going 5 minutes without a legal counsel,
Yeah.
that's, you know, it's up to the board.
Okay. All right, and Susan, less of a pain for you if it's 6:30?
Yeah, but I also want to, you know, I want to be flexible, but I,
Well, it's the happy medium there, so it's not 7.
It's not a critical decision. I mean, 6:30 works for me. I mean, you know, I'll be eager to get out of here now. Some nights we go really late and it's really painful.
Well, we also have that limitation that when it was 7, when we got to 11, we have to have a motion to continue, and we have the option of moving it to another date, the remaining items on the agenda. And we have done that in the past.
Yeah, after making somebody sit for 7 hours.
I know.
I don't want to do that to.
Which is why we usually don't do it.
Yeah, one of those nights I got 5 hours sleep. It was
I know.
It was not
Well,
pleasant.
Some of us do work until 5:30, close to 6, especially in the
Sure, and I totally understand
summer.
that. So I can live with whatever, but
So would someone like to make a motion to modify this to 6:30?
I'll make the motion and modify our start time to 6:30.
Motion from Joe, is there a second? Second from Liz, all those in favor say aye.
Aye.
Okay, 1 nay.
Madam Chair, that does have to, the bylaws do have to be amended to, just like we did last time.
Okay,
I don't believe it requires a hearing or anything, it's just bylaws, so we could draft it, include it in your next work session to show you.
okay, sounds good.
It's kind of an odd one.
And this is the meetings and the work sessions.
Correct.
Yep.
Yeah, for all meetings. We have to get the formal amendment of the bylaws, so it would not affect the next work session in 2 weeks. Legal
That
is
would be
telling
nice.
me an
Okay.
alternative.
Yes,
Right.
please.
Okay.
Very good. If there's nothing else, any other updates from staff?
Just a quick reminder that Dover and Cole is still in town. They'll be here tomorrow, 9 a.m. to 6 p.m. at the Wakefield Elementary School. And then we have the final meeting with them in town at 6 p.m. on Thursday, the 28th, where they will try to summarize all the information they've disseminated throughout the week of being here. So we've received a lot of positive feedback so far.
Absolutely. There's been an enormous amount of community interest and input, and very positive.
Presentation last night was great.
Yes, very nice.
I was really concerned about people actually coming out to do this and getting the word out.
Yes, Well done. Motion to adjourn. Motion from Peter, second from Liz. All those in favor say aye. Aye, motion carries. Thank you, everyone.